Kuroda versus Jalandoni. 83 Phil 171, March 26, 1949. Facts: Shigenori Kuroda, formerly a lieutenant general of the Japanese Imperial Army and commanding general of the Japanese Imperial Forces in the Philippines during a period covering 1943 and 1944, who is now charged before a military commission with having unlawfully disregarded and failed to discharge his duties as such commander to control the operations of members of his command, permitting them to commit brutal atrocities and other high crimes against non-combatant civilians and prisoners of the Imperial Japanese forces in violation of the laws and customs of war. Comes before this court seeking to establish the illegality of EO number 68, which established a national war crimes offices and provides that persons accused as war criminals shall be tried by military commission, and to permanently prohibit respondents from proceeding with the case of petitioner. Kuroda argues that EO number 68 is illegal on the ground that it violates not only the provisions of our constitutional law, but also our other local laws. To say nothing of the fact that the Philippines is not a signatory nor an adherent to the Hague Convention on Rules and Regulations covering land warfare, and therefore, petitioner is charged of crimes not based on law, national and international. Hence, petitioner argues that in view of the fact that this commission has been impaneled by virtue of an unconstitutional law and an illegal order, this commission is without jurisdiction to try herein petitioner. Issue: whether or not the Philippines can adopt the rules and regulations laid down on the Hague and Geneva Conventions, notwithstanding the fact that it is not a signatory thereto, and whether it can create a military commission to try violations of the Hague Convention. Held: yes. Executive Order Number 68, establishing a National War Crimes Office and prescribing rules and regulations governing the trial of accused war criminals, was issued by the President of the Philippines on the 29th day of July 1947. This court holds that this order is valid and constitutional. Article 2 of our Constitution provides in its Section 3 that the Philippines renounces war as an instrument of national policy and adopts the generally accepted principles of international law as part of the law of the nation. In accordance with the generally accepted principles of international law of the present day, including the Hague Convention, the Geneva Convention, and significant precedents of international jurisprudence established by the United Nations, all those persons, military or civilian, who have been guilty of planning, preparing, or waging a war of aggression, and of the commission of crimes and offenses consequential and incidental thereto, in violation of the laws and customs of war, of humanity and civilization, are held accountable therefore. Consequently, in the promulgation and enforcement of Executive Order Number 68, the President of the Philippines has acted in conformity with the generally accepted principles and policies of international law, which are part of our Constitution. Furthermore, when the crimes charged against petitioner were allegedly committed, the Philippines was under the sovereignty of the United States, and thus we are equally bound together with the United States and with Japan to the rights and obligations contained in the treaties between the belligerent countries. These rights and obligations were not erased by our assumption of full sovereignty. If at all, our emergence as a free state entitles us to enforce this right on our own of trying and punishing those who committed crimes against our people.